Good afternoon, everyone, and thank you for joining us for the third edition in our 2020 series of webinars focusing on biosimilars. I'm Matthew Royal, and I will be giving a European perspective today, together with my colleagues Judith Krenz from the Netherlands and Nora Wessendorf from Germany. We're also joined by US colleagues from Wilkie, Farr and Gallagher, Mike Johnson, Heather Schneider and Tara Teamy. And so today we'll be giving a fairly diverse update on a number of different topics. In the US, this will cover sort of skinny labeling, PTAB proceedings and settlements. And from a European perspective, there'll be an update on UK biosimilar guidance, secondary medical use SPCs and purpose-limited patent claims. A couple of housekeeping points before we get started. Please do submit any questions that you might have using the Q&A tab at the bottom of your screen. We'll try and address any questions as we go along, but we'll certainly follow up after the webinar if we don't have a chance to get to any questions that you put in that box. And at the end of the webinar, please do stay on the line to answer a short questionnaire. It really does help us sort of plan future topics so that we can talk to you about what you're going to find useful. But with that, I will hand over to Tara.
Thanks, Matt, and I want to wish all of our U.S. listeners a happy Veterans Day. I think from the U.S. side, we want to kick things off today discussing a recent decision relating to skinny labeling in the United States. So just a little background before we get into the GSK v. Teva decision. A skinny label refers to the practice of a follow-on drug manufacturer seeking approval for some, but not all of the indications for which the reference product was approved for. And under the Hatch-Waxman Act, there's actually a specific statutory section that addresses these types of indication carve-outs, and it's known as the Section 8 carve-out or the Section 8 statement. And this was something that Congress added to the statute to sort of ensure that method of treatment patents do not prevent the launch of a generic drug for unpatented uses. And what's notable here is that in the small molecule context, an AB-rated generic drug may still be automatically substituted for the reference product, even for uses that have been carved out under Section 8. So with that, I want to jump into the background of the GSK Teva case. So in May of 1997, the FDA approved carvedilol as the first beta blocker for the treatment of congestive heart failure. And it had actually had 2 indications approved previously. So this was the third approved indication. The 069 patent originally claimed the methods of treatment for this congestive heart failure indication. In January of 2008, the 069 patent reissued as the 000 patent, and that patent expired in 2015. Now, while all of that was happening, in March of 2002, Teva filed an ANDA with a P4 certification that the 069 patent was invalid, and a P2 certification for the composition patents that covered the actual drug, which expired in 2007. In August of 2007, Teva carved out the CHF indication covered by the 069 patent from its generic label. And in September of 2007, Teva launched under its skinny label. And so Teva was selling its generic carvedilol until April 2011. In April 2011, Teva received notice from the FDA that GSK had actually delisted the 069 patent, and the FDA requested that Teva revise its product to be under the full label. So after 2011, Teva actually sold its generic carvedilol under the full label. In 2014, GSK sued Teva for induced infringement of the 000 patent. So there was a 7-day jury trial in the District of Delaware where Teva argued essentially that because it had carved out from its initial label the indication and prescribing information for the treatment of CHF, Teva couldn't be found to induce prescribing physicians to infringe the patent that covered that treatment, the 000 patent, at least not before Teva amended its label to include all of the indications in 2011. And Teva actually argued even after 2011, because there was no indication of sort of a change in prescribing behavior before and after the skinny label, that they couldn't be found to be inducing infringement during the full label period as well. GSK, however, relied on Teva's marketing materials. Specifically, Teva had a 2008 and 2009 product catalog and a 2009 reference guide that stated Teva's generic products AB rating, and with Coreg, the brand, and actually compared Teva's generic carvedilol to Coreg by name. GSK also noted that in none of Teva's marketing materials did Teva sort of expressly disclaim the treatment of CHF. The jury found that this evidence was sufficient to support willful induced infringement and granted a pretty sizable award to GSK. However, the district court subsequently granted judgment as a matter of law in favor of Teva, finding that the substantial evidence did not support the jury's findings on inducement in either the skinny or the full label period. So let's dig into the district court opinion just a little more. So the district court opinion divided its analysis into both the skinny label period and the full label period. During the skinny label period, the court found that any direct infringement by physicians was caused by factors unrelated to Teva, and that there was no direct evidence that Teva's label, either skinny or full, caused a single doctor to prescribe the generic carvedilol to treat CHF. The district court addressed GSK's indirect evidence, such as the AB rating and the marketing materials that referred to the AB rating and the comparison by name to Coreg, but the district court found that this evidence was not sufficient to support a finding of induced infringement because there's no FDA requirement that a generic specify which uses it is or is not AB rated for. And in fact, GSK's own expert had admitted that an AB rating is actually limited to the use of the drug in accordance to the generic drug label. And during the skinny period, there was no description of treatment for CHF in the skinny label. The court also cited the fact that Orange Book equivalency determinations aren't made for unapproved off-label indications like CHF would have been during the skinny label period, and that neither party's experts had ever seen sort of a disclaimer of a carved-out indication in any marketing materials before this. So it wasn't sort of standard industry practice that doctors could expect and rely on when reviewing these materials. And generally, the court also cited Teva's evidence that when Teva began selling its carvedilol, doctors relied on guidelines and research and sort of GSK marketing and their own prior experience with the brand drug to make prescribing decisions rather than the generic labels applied by Teva. So during the skinny label period, the district court found that there was insufficient evidence to support a finding of induced infringement. During the full label period, the court found similarly that there was no substantial evidence that anything about the behaviors of the doctors, generally, or even evidence of a single doctor, was induced to change by the modification of Teva's label, or anything else that Teva did or didn't do. So with that, the district court entered JMOL in favor of Teva, and GSK subsequently appealed. And that appeal is really what we want to focus on today. So the Federal Circuit recently decided that appeal on October 2nd, and in a 2-to-1 decision penned by Judge Newman and joined by Judge Moore with a dissent by Judge Prost, the Federal Circuit reversed JMOL. And the majority decision did something interesting here in that they didn't actually divide out the discussion between the skinny label period and the full label period, but rather just addressed induced infringement sort of as a whole. And citing the Supreme Court case, a few Supreme Court cases actually, the majority explained that copying a patented product is evidence of inducement that isn't negated when the direct infringers already knew of the infringing subject matter. So in this context, the Federal Circuit was essentially saying just because the doctors prescribing the generic knew of Coreg beforehand, that cannot induce or that does not negate other evidence of inducement. And specifically, the majority cited promotional materials that referred to the AB rating of carvedilol to Coreg, and testimony from GSK's expert, Dr. McCullough, that doctors are, quote, completely reliant, end quote, on information from generic producers and typically receive product catalogs, visit drug company websites, and read product guides. And one thing the Federal Circuit really credited was the direct by name comparison between Teva's generic carvedilol and Coreg. Teva again argued that it couldn't be liable because it had deliberately carved out the CHF indication from its skinny label. The Federal Circuit didn't really give this much weight, though, because the majority pointed out that Teva's 30b6 witness had explained that carving out an indication was a legal strategy, not a commercial one, and that Teva was expected to receive sales from the carved out indication. GSK's expert also explained that a 2007 press release announcing Teva's generic product, it would have been understood by doctors to indicate that it should be prescribed for the full range of approved indications of Coreg. And in support of this, the majority credited a regulatory expert who explained that if you compare a product by name, you're generally saying that you can do everything that named product can do. So as a result, the majority found that this evidence was legally sufficient to support the jury verdict, and as such reversed the district court's grant of JMOL and remanded for entry of the verdict. Now, the dissent actually followed an approach that was similar to the district court in that it addressed the skinny label period and the full label period separately. And the dissent actually really focused on sort of the goals of the statute, of the Section 8 statute, and sort of the realities of why this carve-out is necessary. So the dissent first addressed the statutory background and emphasized that skinny labels were designed by Congress to ensure that one patented use would not foreclose a generic for marketing a drug for other unpatented uses. But that's exactly what has happened here under the majority opinion. And the dissent argued that Teva actually acted exactly as Congress had intended. Teva waited until the compound patents for carvedilol had expired to launch its product, and launched for uses for two unpatented indications, and carved out the patented indications. So this was exactly what Congress intended. A generic launched a generic product earlier than it otherwise could have if it had had to wait for the patent covering the third indication to expire. The dissent also criticized the majority as relying on the quote-unquote the content of the skinny label for supporting a finding of induced infringement, when the skinny label itself did not actually set forth the patented method at all. And you know, the dissent actually found this a little nonsensical, that you could say, oh, you're encouraging a patented use when the skinny label and the cited indirect evidence doesn't actually refer to the method itself. And just as a general rule, the dissent found that this sort of evidence shouldn't be sufficient. As a result, the dissent concluded that the majority's opinion would discourage generics from entering the market in the first instance, because it was ultimately more costly for Teva to sell an unpatented drug for unpatented uses than it would have been to stay out of the market altogether. And the majority actually addresses some of these points in their opinion, and sort of notes that it's the judge's job to apply the law as is, and not to apply sort of prospectively based on business concerns. So because we're here today to talk about biosimilars, we sort of wanted to take a quick look and think about, based on these factors and how the court analyzed induced infringement here, how would this case come out if the product at issue had been a biosimilar rather than an AB rated generic. So first, I'll note that there's no actual statutory equivalent to a Section 8 carve-out in the BPCIA, but FDA guidance does provide that applicants can carve out indications for a biosimilar, and in fact that happens quite often in the United States. However, for an interchangeable product, the FDA has provided guidance that interchangeability would require a showing that the proposed interchangeable product could be expected to produce the same clinical results as the reference product in all of the reference product's licensed uses. So there's a bit of a distinction on whether you have a biosimilar product or an interchangeable product. But I think, it's important to note here that the majority really focused heavily on the AB-rated status of the generic. And with biosimilars, you really don't have that because saying something is biosimilars, it does not carry the same weight as saying something is AB-rated generic. And, I think it's also important to note that some of the indirect evidence of advertising and promotional materials factually may be different for biosimilars than they are for generic products. However, I think even with that, there is still a risk that marketing a biosimilar by comparing it to the reference product by name or sort of in broad terms may be considered circumstantial evidence of infringing a carved-out method of treatment patent. And going forward, biosimilar applicants should carefully scrutinize their marketing materials for any implication that a biosimilar could be prescribed for all indications of the reference product. So with that, I am going to turn it over to my colleague Heather for discussion of recent developments regarding PTAB judges in the U.S.
Thanks a lot, Tara, and thanks for that discussion of GSK versus Teva. I think we're all going to be watching the fallout of that decision and how it gets applied in future cases in small molecules and biosimilars. Very interesting. And now I wanted to just give you all a short overview of what's going on with the Arthrex case. So some of you may have heard of it, both in the U.S. and abroad, and have some idea that the sort of constitutionality of the PTAB judges are up for review by the Supreme Court. And I just want to give you an overview of what the issue is so that as you all watch the news about it and see what happens, you'll have some background. But basically, the constitutionality of the PTAB and the various IPR procedures has been challenged in a couple of different ways since the America Invents Act. Now, in the Arthrex versus Smith and Nephew, the Federal Circuit took a look at the PTAB judge's appointment process and said, hey, these are principal officers appointed without consent of the Senate in violation of the Appointments Clause. And I'll tell you what that is in the next slide or so. But basically, the Federal Circuit said, all right, these PTAB judges can still serve as inferior officers by severing certain protections in the Patent Act that increase their independence. So what does this all mean? There's no dispute here that PTAB judges are officers rather than employees of the government. The question in this Arthrex case is, well, what kind of officers are they and how do they have to be appointed? And so on October 13th, the Supreme Court of the United States granted certiorari to hear this case. And the briefing is going to be starting this month with briefing to be completed in January. And I think we expect to see a lot of amicus briefs filed on both sides of this. So as you're following the news, this is what you're going to hear discussed. This is the Appointments Clause of the U.S. Constitution. And sort of cutting through all this, it basically says that the president has the power, with the advice and consent of the Senate, provided 2/3 of the Senate concur, and to nominate, and with the advice and consent of the Senate, appoint officers of the United States, so ambassadors, judges at the Supreme Court, and all other offices. And people generally refer to that point of the clause as referring to what are called the principal officers. So the Senate has to approve them. Then the rest of the clause says Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts, or in the heads of departments. And that sort of section of the Appointments Clause refers to inferior officers. So as you're gleaning by now, this is not really an IP-specific question. It's an administrative law question and constitutional question. And so how does it play out with the PTAB? What the Federal Circuit looked at, and I'm sure the Supreme Court will look at, are sort of different factors that may be relevant in determining whether or not PTAB judges are principal officers or inferior. So on the side of the scale that they are principal officers, they occupy an office established by law, they conduct duties specified by the statute, they issue final written decisions that are only subject to rehearing or appeal. They have the power to oversee discovery disputes, hear arguments, and take testimony. And importantly, for the Federal Circuit's decision, they could only be removed for cause. Now, on the inferior officer side of the equation, these PTAB judges are appointed by the Secretary of Commerce, again, which would be fine if they're inferior officers. I don't think anyone's disputing that. Sort of above the PTAB judges, the director of the PTO has the authority to issue regulations and policy interpretations that the PTAB judges must follow. No decision of the PTAB can be designated precedential without the director's approval, and the director can even authorize and select the particular panel of judges. Now, what happened in the decision is the last factor here, that they can only be removed for cause, was severed by the Federal Circuit majority. And basically, the Federal Circuit said, all right, by getting rid of that protection, we're basically treating the PTAB judges as inferior officers. So even though the AIA was unconstitutional as written, if we sever part of it, we can basically fix the problem. And so this is going up to the Supreme Court. And so the real issue is whether under this appointments clause, the APJs are principal officers who must be appointed by the president, or inferior officers whose appointment can be in a department head. And if that's the case, whether the Court of Appeals properly cured the defect. So the Supreme Court could come out a couple of different ways. They could say, well, these are just inferior officers in the statute, and so we don't even have to get to that severance point. Or the Supreme Court could say, yes, they are principal officers, but we agree that the Federal Circuit properly severed that clause and fixed the constitutionality. Or conceivably, the Supreme Court could say these are principal officers and you can't fix this through severability. The whole regime is unconstitutional. And so those are the different outcomes that could happen. And that's why so many people are watching the case. The Supreme Court will certainly want to try to make this consistent with other areas of administrative law and constitutional law. And so it'll be very interesting to see how this all plays out. So I'm now going to turn it over to Mike to talk about some issues related to pharmaceutical settlements.
Thanks, Heather, and thank you everyone for joining us today. I will keep this update brief to give our Taylor Wessing colleagues an opportunity to shift more to the European. But this was an important decision that just came down by the Ninth Circuit. Basically, as a little piece of background, I'm sure many of you have heard, the state of California passed a law back in October of last year, basically regulating patent settlements and arguably providing greater antitrust scrutiny on what are called reverse payment settlements, i.e. settlements where something of value goes to the generic in return for staying off the market. Of course, federal law generally governs patents and antitrust, although there are state antitrust laws as well. And California enacted a law that would be more stringent than the federal antitrust law on evaluating patent settlements. The statute defined anything of value very broadly, including exclusive licenses and so-called no authorized generic provisions. Basically, it was much broader in terms of what could be alleged to be compensation going back to the generic company from the brand. But what was sort of most chilling about the statute It provided for civil penalties of up to $20 million, and those civil penalties could be applied against individuals who are involved with the settlement, potentially in-house attorneys, outside counsel, as we'll talk about a little bit later. And sort of a $20 million fine on individuals was viewed by many in this industry as potentially problematic, and certainly having the ability to chill settlements. So the Association for Affordable Medicines, which is sort of formerly generic pharma lobbying group, brought suit in California challenging the law. They challenged that it violated the Dormant Commerce Clause, which basically prohibits states from regulating interstate commerce. So one state can't set up a system of law that impacts interstate commerce. They argued that it was preempted by the federal patent law and the balance that was created by the Supreme Court in antitrust, the intersection of antitrust and patent law and FTC activists, that violated the constitutional prohibition on excessive fines and punishments under the Eighth Amendment and violated due process. The district court judge back on December 31st of last year denied, AM filed a motion for a preliminary injunction to prevent the law from going into force. It was scheduled to go into force on January 1st of 2020. On December 31st, conveniently in time for it to go into law, the judge denied the preliminary injunction. Interestingly, the judge did say that if this law was enforced against parties that were sort of had no connection to California, it potentially would violate the Constitution, but basically decided no violations had occurred yet, so there was no reason to hold it unconstitutional. The AAM appealed, and the appellate decision is what came down recently. But basically, AAM tried all the stops. They moved for a stay pending appeal to prevent the law from going into force. That was denied by the district court. They moved for an injunction pending appeal in the Ninth Circuit. That was denied as well. And then over the summer, the Ninth Circuit finally decided the case. And not only did they sort of didn't reach the preliminary injunction, they went further and said basically that there was no injury alleged sufficient to address the constitutionality of the statute at this point, so they dismissed the case. So rather than sort of denying the PI, they dismissed the case. So obviously the PI never went in. The law's in force now. And the upshot of it is the very next day, AAM filed a second complaint challenging the statute, hoping to address some of the lack of standing issues that the court cited in the Ninth Circuit cited in dismissing this. So basically, the law is in force right now in California. The limits on how far the law goes are still subject to some debate and up in the air. And as of right now, California hasn't attempted to bring an action under its law, but it's out there. AM continues to challenge it, but I think we're going to have to see how this plays out a little bit, and perhaps there actually has to be a fine under it imposed by the courts in California or the regulatory, the executive, the equivalent of the FTC in California before this gets adjudicated. But this is another thing to keep an eye on going forward. The legal challenges were unsuccessful, so now we have to sort of wait and see how this plays out. So that concludes the U.S. portion. For any U.S. attorneys seeking CLE credit, the sort of code that you need to enter on the CLE forms is WFG 1618. That's WFG 1618. And with that, I will turn it over to Matt Royal for the European perspective. Thank you.
Thanks, Mike. That's great, and some interesting updates to keep on in the US. Moving down to Europe and sort of starting off with a sort of with I suppose a UK specific topic. As I'm sure you're all aware, the UK left the EU on the 31st of January 2020. On this date, the European Union Withdrawal Act 2018 repealed the European Communities Act 1972, by which EU law ultimately takes effect in the UK. And at the same time, the European Union Withdrawal Agreement Act 2020, so a very similar name, saved much of the EU law, including the relevant life sciences products regulation. So it continues to apply in the UK until the end of the transition or implementation period. And that implementation period ends on the 31st of December 2020. And so on the 31st of December 2020, unless the UK and the EU agree any free trade deals, we're going to be moving into a different phase of the UK's relationship to the EU. And as I'm sure you've all been following, those negotiations are not necessarily going as smoothly as they might at the moment. But regardless of whether there is a trade deal struck, the EU law that's in effect on the 31st of December 2020, with some technical modifications, will continue to have effect in the UK law on the day after that. But it is a period where there is the potential for regulatory and legal divergence in the UK. I think the biosimilars guidelines that I'm going to introduce illustrate this potential divergence quite nicely. So biosimilars will be regulated under the UK Human Medicines Regulations 2012, which will continue the system of abridged applications that we're familiar with at the moment and has already been established in the EU through the EMA. But the MHRA has issued this consultation on its own biosimilar guidelines. And these contain some revisions to the EMA guidance documents. So they do actually sort of expressly refer to those documents. But they take into account the scientific and regulatory experience that has been gained since the first biosimilar products were licensed in 2006 in Europe, and the complex biosimilars, such as monoclonal antibodies, licensed from 2013. This consultation is open until the 15th of November, and although sort of most of the proposed guidance is sort of very familiar, you can start to see a willingness from the MHRA to be open to quicker and easier approvals for biosimilars compared to the EMA. I think this approach is likely during this consultation period to receive comment from innovators in a similar way to the sort of comments that were filed when biosimilars were mooted in 2006 as a potential route, and then again in 2012-2013 when the monoclonal antibody guidelines were adopted. So although we have the MHRA's proposals at the moment, they may change sort of once the consultation is over and comments are in. So I sort of plan to just sort of outline sort of a few of the key principles of the guidelines today, and to note change and as I say, note changes that may be expected following the consultation. The first point to note is the referenced medicinal product itself. Now, it isn't a requirement that is continue to be available and authorised in the UK. So for the purposes of the proposed guidelines, it's been redefined to include principally products that are or have been authorized for at least 8 years in the UK, and that includes those that are converted from EU marketing authorizations once the UK leaves the EU, finally after the implementation period, but also those that did not convert and so actually are no longer UK authorized. There are some restrictions on that. So in order to use the non-UK reference product in clinical studies, you need to provide evidence that that non-UK reference product is representative of the product that was authorized in the UK, and provide any suitable analytical bridging data. There's also a limit to the number of reference products that can be brought in, and it has to be essentially from a country with a similar scientific and regulatory standard to the UK, and so that includes the USA, Canada, Australia, and Japan. So the MHRA guidance is centered on the principle that a biosimilar development program must establish similarity between the biosimilar and the reference product based on comprehensive comparability exercise to ensure that the previously proven safety and efficacy of the reference product also applies to the biosimilar. So that's so far very, very similar to the EMA approach. It means that the biosimilar should be highly similar to the reference product in physicochemical properties, biological activity and potency, and clinical profiles. In addition, the impurity profile and the nature of excipients of the biosimilar itself must not give rise to concerns. And if there are any differences, these have to be justified with regard to their potential impact on safety and efficacy. Again, very similar to the sort of language and sort of approach taken by the EMA. There's also a requirement that for instance, the amino acid sequence has to be the same, and the posology and route of administration again also must be the same, or require justification and may need additional data. So a few noteworthy points that might start to get into some divergence. First of all, a comparative efficacy trial is not considered necessary in most cases in the proposed MHRA guidance. Although there are express exceptions to this, so there is a degree of discretion on behalf of the regulator, but the default position is that you don't need comparative efficacy trials. Now that's different and can be contrasted to the approach of the EMA, which states that in the absence of surrogate markers for efficacy, it is usually necessary to demonstrate comparable clinical efficacy. So this, I think, represents a change of emphasis and tone, although obviously much will depend on how it's actually applied in practice, because there is still a significant discretion for the regulator. It's probably worth noting at that point that this doesn't mean that clinical trials aren't necessary for biosimilars, because actually comparative pharmacokinetic trials are required under both guidelines. There's no in vivo studies in animals deemed to be necessary, and that's actually for both the MHRA and the EMA, and that's because they're not thought to be useful for demonstrating either efficacy or safety. A couple of other differences. So extrapolation of indications. So if the biosimilar has a number of different indications covering different diseases, the MHRA guidelines suggest that extrapolation to all indications is automatic once the biosimilar is shown to be highly similar in terms of analytical characteristics, and functional properties relating to the mechanism of action. So in contrast, the EMA say that this question, the question of extrapolation of indications, must be considered on the totality of the data. So again, there is still discretion there, but there is a change of emphasis and tone in the guidance. Finally, just on interchangeability, and I think there's a particular category for interchangeable biosimilars in the US. The EMA doesn't concern itself with interchangeability. It sort of expressly says that it's not competent to make any pronouncements on interchangeability. The MHRA, however, says that once a biosimilar is authorized, it is and will be considered interchangeable with the reference product, which means that a prescriber can choose the biosimilar over a reference product and vice versa, and expect to achieve the same therapeutic effect. However, it is worth noting that this doesn't mean that we're moving towards a generic version. All biologics, and including biosimilars, have to be prescribed by brand name, and any switching decision rests with the prescriber or the physician, who needs to be aware of the brand and the data behind it. There is still no substitution permitted at the pharmacy level where the prescriber is not consulted. So again, this is a change, and perhaps that changes because of the competence of the MHRA to comment on prescription and prescribing practices in the UK, whereas the EMA doesn't have that competence. So, as mentioned, the consultation period ends on the 15th of November. It will be seen how many of these points are retained in the final guidance. But the intention of the MHRA to provide a different tone to the guidance is fairly clear. How that translates to practice will remain to be seen. And with that, I will hand over to Judith to talk about second medical use SPCs.
Thanks, Matthew. I'm going to discuss a highly debated ruling handed down by the Court of Justice of the European Union in July 2020, which deals with the conditions for granting an SPC under Article 3 of the SPC regulations. In this case, Santen, a Japanese pharmaceutical company specializing in ophthalmology, had received marketing authorization for a product called Ivercus, which concerned an eye drop emulsion for the treatment of severe keratitis, which is an inflammation of the cornea in adult patients. The active ingredient used in this product was cyclosporine. Santen also held a basic patent for this product and therefore applied for an SPC in France. Santen's application was rejected by the French Patent Office on the grounds that marketing authorization for Ivercus was not the first to place the product on the market. It turned out that in 1983, marketing authorization had already been granted for a product called Sandamune, an oral solution for, among other indications, treating inflammation of the uvea, which is the middle part of the eyeball, with the same active ingredient. Therefore, the French Patent Office argued that one of the conditions for granting an SPC had not been met. In the following, the French Court of Appeal eventually referred the case to the Court of Justice of the European Union. Although the issue was quite clear based on the literal meaning of the regulation, namely, there had obviously been a previous marketing authorization for the same active ingredient, the argument was made that Ivercus was not the same product under the court's previous ruling in Neuron. In Neuron, a decision handed down in 2012, the court held that SPC protection for a different application of a known active ingredient was permissible. In that case, there had been a prior marketing authorization for a veterinary product, and the second use, unlike the first use, was within the scope of the basic patent. In Neurim, the court essentially permitted SPCs for second medical use. However, in Santen, the court rejected the Neurim decision, interpreting Article 3 in its literal sense. The court held that a marketing authorization for a second medical use is not the first authorization of the product pursuant to the SPC regulation. Thus, it held that no SPC protection can be granted for the second medical use of an active ingredient. So, where do we stand after Santen? In Santen, the court continues to apply a more restrictive interpretation of the SPC regulation, which, at least in this case, is stringent and in line with the wording of Article 3G. However, it leaves originators with the dissatisfactory result that SPC protection cannot be granted for the second medical use of an active ingredient. The ruling has been viewed as dissatisfactory for a number of reasons. First, it could well result in the invalidation of the whole class of second medical use SPCs. For instance, the German Association of Researching Pharmaceutical Manufacturers, VDA, noted that 22% of innovative drugs launched in Germany in 2019 concerned a new formulation of an active ingredient. For these products, SPCs could not be granted under Santen. Further, the prospect of obtaining SPCs on medicines repurposed for use in subpopulations has disappeared. If the aim is to advance so-called personalized medicine, relying on already known and approved active ingredients is vital. However, this does not exempt pharmaceutical companies from both costly and time-consuming preclinical and clinical trials which, from an economic standpoint, are less desirable if no SPC protection is granted. Also, the legislative purpose of the SPC regulation, which is to ensure amortization of the considerable costs incurred in drug research and development, is equally pertinent to personalized medicine. In future, if SPCs are to cover second medical use products or products repurposed for treating subpopulations, the SPC regulation will have to be amended. It therefore remains to be seen whether legislative changes will be introduced at EU level. On that note, I am going to hand over to my colleague Judith. Thank you.
Yes, thank you, Nora. I will be the last speaker of today, and I know we're nearing the end of the webinar, so I will be short. The subject brings us back to the start of this webinar, actually, to carve out and skinny labeling. So I would like to say a few words about enforcement of second medical use claims in Europe. As some of you know, in Europe we have two different types of second medical use claims. The one is called the Swiss type claim. That was a claim sort of created or invented by the Swiss Patent Office because you couldn't claim a treatment, you couldn't patent a treatment. But in 2020, one thought that is a bit complicated the way those claims were drafted, and there was a new structure of claiming second medical uses, which we call the EPC 2000 claims. In several jurisdictions, there have been debates about whether the scope of protection of those two types of claims are different. And I only want to say that there's no conformity in Europe with respect to those claims. In the UK, it's generally said there is a different scope of protection, and in the Netherlands and Germany, there's no difference in scope of protection. Shortly, it will not matter anymore because most patents with this type claims have been expired or will expire very soon, so then we only have EPC 2000 claims. With respect to infringement tests of second medical use claims in Europe, there's unfortunately no conformity among the European courts either. what I can say in general, a carve-out or a skinny labeling is in most situations not sufficient to avoid an injunction for the biosimilar or generic manufacturer. But the tests applied by different courts are sort of multiple. I think we're counting 4 or 5 different tests now. The UK Supreme Court seems to favor what we call the outward presentation test, which is basically based on the idea that what is really important is how the pharmaceutical company concerned does present his product. So that's determinative whether or not there is or can be infringement. But it's the Court of Appeal in the UK has said, well, no, it's a reasonable foreseeability test, and that test implies that the generic or biosimilar should reasonably foresee infringement, or reasonably foresee that his product is used for the still patented invention, even though maybe in the label it's carved out. That test is also applied in the Netherlands, but in the Netherlands we say it's a qualified foreseeability test, and basically what you have to do, you have to carve out your a certain treatment. Then you have to show as a generic or a biosimilar company that you have taken all measures to avoid infringement, so that infringement is no longer a foreseeability. And if the patentee is still of the opinion that there is or can be infringement, the burden of proof will shift to the patentee to show that there is indeed infringement. In Germany, it's also a sort of a foreseeability. Also, with respect to carve out may not always be sufficient, but there might be more pressure based on a decision of, I think, 2 years ago in Sylvestrant, an AstraZeneca product, that the burden of proof is a little more on the patentee than on the alleged infringer. Well, the conclusion from this is that there is no conformity. I know we're running out of time, so I will keep this really brief. A few words on personalized claims, which are sort of second medical use claims. But for example, a new subgroup of patients has been found. The only thing I want to say about that is that showing infringement and taking measures to avoid infringement is even more complicated than with general second medical use claims. And there's often a question raised whether the patentee should allow some low amount of infringement, a low percentage, a threshold, for example. With that, I hand over to Heather to close this seminar.
Thank you, Judith. Obviously, there's a lot of really interesting things going on in the U.S. and Europe with respect to different methods of use and indications that we'll definitely be following in the next year. I wanted to thank our friends at Taylor Wessing and everyone who's attended our webinar series this year and for the last couple of years now. This is the last one for 2020, and we hope that everyone has a wonderful holiday season and a wonderful new year, and we'll see you all again next year.